Let's listen to Pavarotti.
Hello, welcome to The Revealing. I'm your host Pavarotti, and I'm here to discuss the Idaho 4 case. As a disclaimer, this channel is for entertainment purposes, and these are my opinions. I'm not here to slander anyone. I will provide information and give you my opinion on the information I provide. In this episode, we're going to discuss the motions. No, we're going to discuss the rulings and a motion that was just filed. So, all 12 motions on the death penalty have been denied by the judge. And if you recall, as I covered this, there was one motion that I thought we had a good chance on. Well, I'm going to break down in this video what happened with that particular motion. The other 12 that were denied, the other 11 that were denied, they were all based on constitutionality arguments, and they had to be made, because if they weren't made, guess what? They would be denied anyway. So, and we discussed what happened with a lot of those constitutional arguments. They've been denied in many courts. Same arguments. I thought we had a chance with the speedy trial argument because of the factors and circumstances that went into it. But now that I've had a chance to look at it again, look at the judge's opinion on that particular argument, I've learned a few new things, and I want to cover those with you in this video. And we're also going to go into some positive aspects of a motion that was just filed by Bill Thompson. So stay tuned in this one. But I think once I'm done with this, you'll clearly understand what happened with that argument, the positive that we can take from it, because I now don't believe that Ann Taylor, number one, she didn't even write that argument. I thought that was her argument, but she didn't write it. She argued it, and I believe she was saving her argument for a different time, and I'll explain that in this. So let's just get right into it. Focusing on this one, this is the motion to strike the death penalty on grounds of speedy trial, preventing effective assistance of counsel. In seeking to strike the death penalty, and this is the judge's opinion on it, defendant's multifaceted argument begins with the premise that this court should overrule decades of Idaho appellate precedent and conclude that the right to a speedy trial guaranteed by Article 1, Section 13 of the Idaho Constitution should no longer be governed by the Barker factors, but should be subject to a 6-month speedy trial clock. Now, a couple of things I want to point out right here is, number one, Ann Taylor tried her best to argue around the 6-month speedy trial clock. In fact, she went as far as to definitively state that she was not trying to do that.
I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all.
So while she made a valiant effort to argue that she wasn't arguing that the speedy trial should be a 6-month time clock, as the judge put in his ruling, inevitably she was struck down because of what's called the Barker factors. Let's look at Barker. See, the Barker rule is a Supreme Court ruling in Barker versus Wingo that established a balancing test to determine if a defendant's right to a speedy trial was violated. And what they used to determine that is length of delay. The court considered how long the delay was. Governmental reasons. The court considered whether the government had a good reason for a delay. And then the defendant's responsibility. The court considered whether the defendant actively invoked their right to a speedy trial. And that is the one that seems to be the hang-up, because of the decision that was faced by the defense. If they would have continually invoked their right to a speedy trial, then the prosecution would have absolutely took them to trial without giving them all their discovery. So it really was not a fair choice. But the argument in this case, I believe, is being held for a later date. And here's another reason why this particular motion did not go down as well as it should have.
Mr. Logsdon wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial, in the same time frame that the statute 1935-01 says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into history, that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking.
So once again, I originally stated I thought this was Ann Taylor's argument. I didn't pay close enough attention, because as you heard her state right there, Jay Logsdon wrote the brief for this argument. And she's trying to argue Jay Logsdon's brief. And you see what happened right there. The judge, who was very familiar with the argument that Jay Logsdon had written, came back with his opinion on it. And because Ann Taylor did not write the argument and wasn't familiar enough with the argument that Jay Logsdon had written, because Jay Logsdon was supposed to argue it, he caught her not being able to comprehend his response to her. And I've had people try to defend Jay Logsdon for not being at that hearing. They said, well, he was at another hearing and the judge knew that and he approved him being late. Well, folks, let me tell you something. If you spend any time in a courtroom, even in traffic court, if you have an attorney, you'll see the judge is very, very lenient on scheduling things around that attorney's current caseload. Attorneys always keep a very, very detailed log with them, itinerary, so they can, appointment book is what I'm trying to say, I guess. And whenever they're scheduling a hearing, the judge will ask all parties. They say, well, is this date good for you? They look at their appointment book and they say, no, I have another trial scheduled on that day, and they schedule around it. So when you look at the possible obligations that Jay Logsdon had, there was only one hearing going on in the state of Idaho regarding the death penalty on that day. And that day was known about far in advance. And Jay Logsdon had written the 12 motions on the death penalty. Those were his arguments. So any other hearing that he may have been obligated to, I assure you, he could have got it rescheduled so that he could be at that hearing, because that was obviously the most important thing that he could be doing that day. So nobody make excuses for Logsdon's absence in that hearing, because there is no excuse. And you can see by his absence the effectiveness of the other counsel trying to argue his motions. I blame Jay Logsdon for that one. Let's continue. But again, you can see Article 1, Section 13 of the Idaho Constitution should no longer be governed by the Barker factors, but should be subject to a 6-month speedy trial clock. As I just stated, she was trying to argue against that. But he then asserts that as a capital defendant, he cannot obtain effective assistance of counsel within a 6-month period. Thus, at the time he waived his statutory and constitutional speedy trial rights, he was presented with an unconstitutional Hobson's choice between his constitutional right to a speedy trial and his constitutional right to effective assistance of counsel. Okay, so the judge's opinion is that Kohberger was presented with an unconstitutional Hobson's choice, or the defense's assertion is he was presented with an unconstitutional Hobson's choice. So let's look at what a Hobson's choice is. An apparently free choice when there is no real alternative. The necessity of accepting one of two or more equally objectionable alternatives. So a Hobson's choice in this matter is choosing from between two wrongs. So there's no right answer in a Hobson's choice. Both decisions would be of detriment. So because the judge didn't agree with it being a Hobson's choice, it's this first paragraph that can sum up why all of these motions for the death penalty were denied. And the judge even let us know in court. He said, Article 1, Section 13 of the Idaho Constitution should no longer be governed by the Barker factors, but should be subject to a 6-month speedy trial clock. And he refers to the Barker rule as his reason for denying everything.
And trying to figure out what the word speedy means. And so,
Well, isn't speedy mean the Barker test?
well, at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
However, you can see at the bottom here, it says the state points out that well-settled case law, which is binding on this court, and she's referring to Barker, provides otherwise. Further, the state notes that defendant waived his speedy trial rights, which is dispositive of any contention that such rights have been infringed. The state is correct. Now, this is the part of it where I really thought that Ann Taylor's argument would have merit in this case. But as I look at it now, I don't believe Ann Taylor truly believed that she was going to win the argument at this stage of this trial or this case. I believe she is actually saving this argument for later. And let's listen to the argument real quick, and then I'll explain what I mean by that.
Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now.
You see, that was always the strongest argument that I thought they had with removing the death penalty, because there is precedent with the Lori Vallow case. The only problem is, in the Lori Vallow case, Lori Vallow never did sign away their right to the speedy trial. They asserted their speedy trial rights throughout the case, even though that it kept getting continued due to discovery issues. So the fact that they didn't have their discovery, I thought was a strong argument for Ann Taylor to make. And you know, her argument was, let's reinstate speedy, get rid of the death penalty, and schedule the trial sooner. Well, again, that tells us that Ann Taylor has everything she needs to go to trial. They wanted to get the death penalty removed so that they could seat a jury that wasn't predisposed to convicting during the guilty phase. But I think she knew at this point, now that I've really looked at this, that there was no way she was going to win the argument on removing the death penalty, because if the judge ruled to remove the death penalty, it would have set a precedent that would have had, tremendous effects throughout the state of Idaho on anybody being charged with the death penalty. He would have effectively eliminated the death penalty for all cases if he would have ruled in favor of the defense in this motion. So Ann Taylor, I believe, wisely is saving that argument for a different hearing. And that hearing, I believe, will be the motion in limine hearing where she will really make that argument strong. And she even gave us a hint during that portion of the testimony.
We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now. I'm not arguing about that right now. I'm not arguing about that right now.
So that being her strongest argument, I felt in all of the motions, and the fact that she clearly states she's not arguing that right now, that leads me to believe that she is saving that argument for the April motions in limine hearing, and she's going to use that argument to get some type of concessions in this case. And I don't know yet what those concessions are, but you can bet she has it in her back pocket to get a concession on something. So the final outlook is it looks like they are going to seat a jury that is death penalty qualified, which means they are more likely to convict during the guilt phase, which now means that all of the motions to suppress, along with whatever she has up her sleeves with the motions in limine hearings, are very, very important to the defense's case at this point. But now let's move on to a more positive note. Now we're going to move on to a more positive note, which is the motion that Bill Thompson just filed. And this motion tells us that there's something wrong with the ship that he's sailing. His crew is either rocking the boat or he feels like they're not adequate to help him in trying this case for whatever reason. So either there's dissension or he's looking for somebody that is very, very strong to help him with his weak case. And this motion tells us everything we need to know about that. And you can see this is an amended petition for appointment of Special Assistant Attorneys General. And it says, come now, the Latah County Prosecuting Attorney William Wolford Thompson Jr. So this is Thompson's motion. And pursuant to Idaho Code, he petitions this court for an amendment of the petition for appointment of Special Assistant Attorney Generals filed herein. So he wants an amendment to the petition that he had already filed and been granted, and he was given two Special Assistant Attorneys General, Nye and Beatty. And it says, I'm the duly elected Latah County Prosecuting Attorney. I have the duty to prosecute all felony criminal actions committed in Latah County pursuant to Idaho Code as prosecuting attorney. I have sought assistance in this case to utilize the expertise and additional resources of the Office of the Attorney General. The Attorney General's office has agreed in writing to assist Latah County Prosecuting Attorney's Office in this matter. Pursuant to the written agreement, the Attorney General's office agreed to pay the salaries of its personnel who assist in the prosecution. So I think it's interesting that he notes that the prosecuting attorney's office, per the written agreement, so he's citing a written agreement between the two, and he's citing the fact that they've agreed to pay the salaries of its personnel who assist in the prosecution. Now, I think that's an important thing for him to put in there, because what he's asking for, I believe, is an upgrade in counsel. And with any profession, if you get an upgrade, guess what? That upgrade, usually costs more. So if he's asking for a higher paid assistance, then he's noting in there that he doesn't want Latah County to pay for it because the prosecuting attorney's office has already agreed to pay for it. So even a higher paid assistant would not negate what the written agreement is already stated. Very sly on William Wolford Thompson. But we got to ask ourselves, why is he asking for this? And you can see it says the nature of this case and its prospective duration may require the transition of assigned deputy attorneys general to meet staffing needs. So he's putting in the little statement, it's prospective duration. Well, when he was granted the special assistance of these attorney generals, that was April 24th, 2023. This trial is going to happen less than a year and a half after that date. You can bet there is nobody that assumed that the trial would happen that fast. So for him to cite prospective duration like it's taken longer than it should have as reason to change his counsel is disingenuous on his part at the very least. But the true reason you can see is what he states first, the nature of this case. So what he's saying is the nature of this case demands stronger counsel to prosecute it. And I petitioned this court to amend the appointment filed herein on April 24, 2023, to appoint the chief of the criminal law division or his designee as a special assistant attorneys general to assist in the prosecution of State versus Kohberger, so as to facilitate the prospective transition of assigned deputy attorney general as may be appropriate. So either Nye, Beatty, or both have said there is something very wrong due to the recent filings by the defense in the motions to suppress, or they said this is way over our head. It's one of the two. So he is requesting, he's really requesting not just another attorney's general, but the chief of the criminal law division. I mean, he's saying that he wants as big a gun as he can because this thing is getting out of his control. You can absolutely bet on that. That tells me that the motions the defense just filed have this Santa Claus figured puckered up. And that is something I think we can look as a very positive in the case so far. So once again, I'm here to tell you that the media, along with the guilters and the uninformed, are all going to state how big of a defeat this is for the defense. And while I do agree that it was a defeat, they lost a battle, it certainly doesn't mean they've lost the war. This was a battle that the defense was prepared to lose, and I, looking back now a little closer at things, believe that they knew they were going to lose this battle. And that's why they didn't fire all of their guns during this battle. They saved ammunition for a later battle. Now, I do believe there was a chance this could have gone a little bit better for the defense had their counsel show up to the hearing, but he didn't, so we're going to move past that. Now, it's going to be very interesting, though, to wait and see the outcome of these motions to suppress and the request for the Franks hearing that's coming up. I think there is reason for us to all be rather positive about the outcomes of these due to what we just seen in that motion from Bill Thompson. That wouldn't have been filed had Bill Thompson not had something that has got him puckered up about it. And if Bill Thompson's puckered up, that is a good sign for the defense. So let's keep our eyes open. Don't let the guilters, the uninformed, and the media, though, tell you that this is a terrible, terrible thing for Kohberger. It's simply a battle that he lost in the many battles of this case. But in the end, he's no further back from winning the war than he was before those motions were even filed. So please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.